Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast. This is the podcast where we use AI to help us study for the bar exam. Again, this episode is specifically on omitted terms, implied terms, parole evidence, all that sort of thing. And sometimes these things can be a little bit hard to grasp whilst you're studying. So hopefully Maud and Claude make it clear. So, just before I hand it over to them, I wanted to speak a little bit about preparing yourself, preparing your mind for the bar exam. One thing I use to prepare for the bar exam is that I actually hired a bar coach. So, you would think the prospect of passing the bar and being an attorney would be enough to really get me focused on studying. But because I have ADHD, I really sort of struggle with executive functioning. So I found a bar coach to really help me focus and study. Now, a bar coach doesn't teach you the black letter law. You still need, or I highly suggest, one of the big box bar study programs. We're talking Barbary, Themis, Quimby, UWorld, whatever is out there. A bar coach holds you accountable for your progress. So it's someone you check in for. So if you're someone who has really good discipline and you're really good at setting your own goals and achieving them, then you probably don't need a bar coach. But for me, the whole topic of the bar exam, it was so vast. I felt like I don't even know where to start studying. And so I know that you get guidance. Like I did the Barbary program, I did the Quimby program. So you do get guidance on there. But as someone who has ADHD and I receive, extra time on the bar exam, I really needed someone to help me really focus and nail down my MBEs. And with my bar coach, I was able to improve my MBE score 20 points from one bar exam to another. So that was fantastic. So there are different bar coaches out there. I have used the 1,000 Lawyer Project, which I think is really good. And even though I didn't pass the bar exam, I'm not putting that on them. So it's on me because, I could have studied more. I could have, there's more things that I could have done, but they're there to support you, morally. They're there to help you get past certain areas of the bar. And these are lawyers, so they're not just coaches. So, if you needed them to teach you the black letter law, yeah, they could. But what they're really good at is helping you adjust your mindset, helping you adjust your schedule, figuring out where your weak spots are and readjusting. And that sort of personal attention is not what you get from Barbary or Quimby. With the exception of with Barbary, if you sign up for their big program, the one that you pay $4,000 for or $6,000 for, you'll get a personal bar coach. But even so, I had weekly check-ins with her and which was great. But, when you have a personalized bar coach, I'm able to call them. Seriously, it could be 11 o'clock at night and I could say, oh my God, I'm freaking out. I don't know torts that well. I wouldn't call them that late, but I could. And they would just be able to sort of talk me off the ledge. So there are different bar coaches out there. I recommend the 1,000 Lawyer Project. And they've really sort of helped me focus and help me study. And they also have these intensive weekends where it's like a bar boot camp. And what's exciting is I'm going to one of their intensive weekends in Puerto Rico. So I leave tomorrow. I'm so excited. Anyhow, so without further ado, let's get into it with this podcast. We're going to go over parole evidence and all that jazz. All right, Claude and Maud, take it away.
All right, welcome back to your personalized deep dive. You're right in the thick of bar prep, and you asked us to really hit a core area, one that can feel pretty complex.
Contradict.
Content and meaning.
Yeah, definitely.
We've got your law school notes right here, your outline, and the plan is simple. Extract the absolute must-know rules you need for those contracts questions.
Especially focusing, like you said, on parole evidence interpretation
Yeah.
and, those omitted or implied terms. They pop up all the time.
Exactly. So let's cut through it and get you feeling confident.
Okay, so when you're looking at a bar exam hypo, you've figured out offer, acceptance, consideration, there is a contract. The next big question is, well, what does it actually say?
Right. What do they actually agree to do? What are the obligations?
Well, precisely. And answering that what, as your notes point out, isn't always straightforward. You've got this fundamental split, right?
Common law versus UCC Article 2. Always the first filter. Remind us again, quick differentiator for the exam.
Think tangible, movable stuff. Goods, a car, books, lumber. Anything like that at the time it's identified to the contract. That's generally UCC Article 2 territory.
Okay.
Everything else, services, real estate, employment agreements, that falls under common law.
And what about those contracts that have both? Like installing a new appliance?
Good question. Your notes flag this. Courts usually look for the dominant purpose. Is it mostly about the service or mostly about the goods? That usually controls.
Usually.
But there's a neat little exception, sometimes tested. If the payment is clearly divided between the goods and the services, then you might apply the UCC just to the goods part and common law to the service part.
Ah, okay. That's a handy detail to watch for in the fact pattern.
Definitely.
Now, staying within the UCC for a moment, your notes mention merchants versus non-merchants. Why is that distinction important for you on the bar?
It's crucial because some UCC rules apply differently or only apply if a party is a merchant.
And a merchant is.
Generally someone who, deals in those kinds of goods regularly or holds themselves out as having special knowledge or skill about those goods.
Like a car dealer selling cars, not someone selling their personal car once.
Exactly. And this matters for things like, well, the big one is the implied warranty of merchantability. That only comes from merchants.
Okay, so when you see sale of goods on the exam, your next thought should be, is anyone here a merchant?
Yes. It's a key question. It can change the whole analysis.
Got it. Okay, let's pivot to something I know causes a lot of bar prep stress. The Parol Evidence Rule. Lay out the core idea for us. What's it trying to do?
At its heart, the Parol Evidence Rule is about finality. If parties put their agreement in a writing, and they intend that writing to be the final word on their deal.
An integration, right? That's the term your notes use.
Like an integration. If it's intended as the final expression, then the rule generally says you can't bring in evidence of things said or written before that final writing, or said orally at the same time if that evidence contradicts or even just adds to the written terms.
So it protects the written contract from being undermined by earlier chatter or side deals.
Basically, yes. The idea is, if it was important, it should have been put in the final writing.
And the bar examiners love testing this, right?
Yeah.
Someone tries to bring up a prior conversation to change the meaning of the written words.
Absolutely. And the first step is figuring out the level of integration. Is it completely integrated, meaning the parties intended it to be the exclusive statement of all terms?
If so, then that prior evidence contradicting or adding terms is generally out.
Correct.
Yeah.
But if it's only partially integrated, final on some terms, but not necessarily all, then extrinsic evidence might be allowed to supplement the written terms but still not contradict them.
Okay, so determining that level of integration, complete or partial, is key. But, like always in law, exceptions.
Always exceptions. And for the bar, knowing the exceptions is often more important than the basic rule.
So when can you bring in that outside evidence, even with a final-looking written contract?
Okay, number one, ambiguity. If a term in the writing is genuinely unclear, ambiguous.
Like your notes example, a three-pronged widget. What is that?
Exactly. If the term itself doesn't make sense or could mean multiple things, you can bring in outside evidence to explain what the parties meant by that specific term. It's about clarification, not contradiction.
Makes sense. What else gets past the rule?
Well, there's a whole category related to the context of the deal. Course of performance, course of dealing, usage of trade.
Okay, break those down quickly for bar review.
Sure. Course of performance is how these parties have been acting under this specific contract. Are they consistently interpreting a term in a certain way through their actions? That gets very high weight.
Okay, performance under this contract.
Course of dealing is about how these same parties acted in past similar contracts between them, their prior history.
Their established pattern.
Right. And usage of trade is about industry customs. What's standard practice in that particular business or field?
And how do these interact with the written contract under the rule?
Okay, this is important. Course of dealing and usage of trade can often be used to explain or supplement the writing, even if it looks fully integrated. Course of performance is even stronger for interpretation.
Even if it's fully integrated.
Yes, especially course of dealing is often allowed to explain or supplement. Usage of trade can supplement or interpret as long as it's reasonably consistent with the express terms.
Yeah.
Though be careful, many places say a clear usage can't completely negate an express term.
And a tricky point, you mentioned trade usage can bind people in the trade, even if they didn't personally know the custom.
Yes, that's a classic bar exam twist. If you're in the trade, you're often held to its standards.
Okay, so ambiguity and in this context, course of performance, course of dealing, usage of trade. What other doors are open?
You can always bring in evidence to show that the entire agreement was subject to a condition precedent, something that had to happen before the contract even kicked in.
Like, this deal is only final if I get financing.
Exactly. Also, evidence showing fundamental problems with the contract itself. Lack of consideration, illegality, fraud, duress, mistake. These aren't barred because they attack the validity of the agreement itself.
Makes sense. You're not trying to change the terms. You're trying to say the contract shouldn't even exist or be enforced.
Right. And similarly, evidence to support a claim for reformation where you argue the writing itself contains a mistake, then doesn't reflect the actual prior agreement,
Like a typo in the price.
for instance. And finally, a crucial point. The rule only blocks prior or contemporaneous stuff. It does not block evidence of modifications made after the written contract was signed.
Okay, that's a lot of exceptions. So, Angela, key takeaway for the bar. The rule looks strict, no contradicting a final writing with prior stuff. 3T, be hypervigilant for the exceptions.
That's where the points are often scored. Ambiguity, context, performance, dealing, trade, conditions precedent, validity challenges, reformation, and subsequent modifications. Know them cold.
Absolutely. Now, let's assume we have a clear written contract. It's survived parole evidence scrutiny. How do we interpret the words in it? What's the approach?
The guiding principle is the objective theory. Courts look at what the words would mean to a reasonable person in the position of the other party.
Not what I secretly intended them to mean in my head.
Nope. Your subjective intent generally doesn't matter. It's about the objective manifestation, the outward expression. What would a reasonable observer, knowing all the context, think the terms mean?
Okay, objective standard. And if there are different potential interpretations, is there a pecking order?
Yes, there's a hierarchy. Your notes lay this out. Express terms, the actual words written in the contract, are given the most weight. King, like you said.
Right.
Then comes course of performance, how they've been acting under this deal. That's very persuasive.
Okay.
Then course of dealing their past history together. And finally, usage of trade general industry customs.
So, express terms, course of performance, course of dealing, usage of trade. That hierarchy helps resolve conflicts.
It does. It provides a framework. And weaving through all of this is that implied duty of good faith and fair dealing.
Ah, yes, the ghost in the machine of every contract. How does that play into interpretation?
Well, it requires parties to act honestly and, fairly, not to do anything that would undermine the other party's ability to receive the benefits that they bargained for. So, if you have two possible interpretations of a term, a court might lean towards the one that aligns better with good faith, the one that doesn't allow one party to exploit a loophole unfairly.
So it kind of prevents technical compliance that violates the spirit of the deal.
Exactly. It's a backstop against sharp practices.
Okay. Now, what about when the contract is just silent? When terms are missing? Omitted or implied terms. How do we fill those gaps for the exam?
Right. This happens, especially under UCC Article 2 for sale of goods. If the parties clearly intended to make a contract and there's a reasonably certain basis for giving a remedy, but they left out some term.
But not quantity, right? Your notes emphasize quantity is usually essential under the UCC.
Generally, yes. Quantity usually needs to be there. But if they left out things like price, delivery time, or place, payment terms, the UCC has gap filler provisions.
Meaning the UCC itself provides default reasonable terms.
Exactly, like a reasonable price at the time of delivery, delivery at the seller's place of business, payment due on deliver. The UCC tries to save the contract if the parties intended one.
So the UCC is pretty helpful there for goods. What about common law contracts?
Common law courts can also supply reasonable terms if the intent to contract is clear, but they tend to be a bit more hesitant, especially if the missing term seems really central, really material.
And what about those terms to be agreed on later situations?
Yeah. Under common law, if a material term is left for future agreement, that can often make the contract too indefinite to enforce. Courts generally won't step in and impose a term the parties couldn't agree on themselves.
But the UCC is maybe more flexible.
It is, particularly regarding price. The UCC has provisions that can allow a contract to be formed even if the price isn't settled, provided the parties intended to be bound.
Okay, so UCC more willing to fill gaps, especially price. Now, beyond gap fillers, what about terms implied by law? The ones that are there, unless you kick them out.
These are huge for the bar. Primarily the UCC implied warranties. You've got the implied warranty of merchantability.
Which is?
If the seller is a merchant dealing in those kinds of goods, the goods are automatically warranted to be fit for their ordinary purpose, like a toaster toasts bread.
Okay, merchant seller, ordinary purpose. What's the other main one?
Implied warranty of fitness for a particular purpose. This one's different. It arises if the seller, merchant or not, knows the specific reason the buyer needs the goods.
Like, I need boots specifically for climbing Mount Everest.
Right. And the buyer is relying on the seller's skill or judgment to select suitable goods. If those conditions are met, there's an implied warranty the goods will be fit for that specific particular purpose.
Got it. Seller knows purpose, buyer relies. Any others implied by law.
Your notes mention the duty of best efforts in UCC exclusive dealing contracts. If you have an agreement where a seller agrees to sell only through a particular distributor, the law implies a duty for the seller to use best efforts to supply and the buyer to use best efforts to promote the goods. It's a default rule.
Okay, so merchantability, fitness, best efforts, all potentially lurking in UCC contracts unless disclaimed properly.
Correct. And then there are terms implied by fact, sometimes called constructive conditions.
How are those different?
These aren't imposed by law generally, but are read into the specific contract because they're necessary to make the agreement work as intended. The example in your notes is great. If a landlord has a duty to repair, there's usually an implied duty on the tenant to notify the landlord that repairs are needed.
It's not written, but it has to be true for the landlord to even be able to perform their side.
Exactly. It's implied by the logic of the situation and the parties' apparent intentions.
Okay, this is really helpful. So, Angela, boiling down for bar memory banks. UCC gap fillers can save contracts missing non-quantity terms if intent is clear.
Right.
Implied warranty of merchantability. Goods from a merchant fit for ordinary purpose.
Yep.
Implied warranty of fitness. Seller knows buyer's specific need, buyer relies.
Go at it.
And always that underlying duty of good faith and fair dealing in every single contract.
Absolutely. Nailing down those implied terms and the interpretation rules alongside parole evidence is just critical.
Okay, Angela, we've really dug deep into content and meaning here, focusing hard on parole evidence, interpretation, and these omitted and implied terms all geared towards what you'll face on the bar.
Yeah, hopefully this unpacks it in a way that clicks, highlighting those rule statements you really need locked in.
Remember, understanding how these pieces fit together, the writing, the exceptions, the interpretation rules, the implied stuff, that's the key. Keep practicing applying them to hypos.
And don't hesitate to rewind and listen again if something's still fuzzy. You've got this.
Absolutely. Best of luck with the final push of the bar.
Hey, I'm back. It's Angela, your living, breathing, human podcaster. And I hope you enjoyed that on parole evidence and omitted terms and implied terms and stuff like that. Our next podcast will be on, performance breach and discharge. This is the exciting part of contract law where you get to see what to do when things go wrong. So a few reminders before we head out. 1, I am not a lawyer and I am not providing legal advice. 2, AI sometimes isn't always correct. So take all of this with a grain of salt. This, by the way, shouldn't be the only way you're studying for the bar. This is a supplement. This is, what you do between things. So if you are driving in your car, or if you're flying on a plane, or if you just have some downtime, maybe you're jogging or whatever, this is what you listen to, so that if you want to maximize your bar study time, this fills in. But please don't make it the only way you're studying for the bar, because you'll need more than just this. And I'm not an expert. I'm just figuring things out for myself. I'm winging it. And, I used to do a podcast ages ago that I would get millions of downloads per month. And so I know how to do this podcast thing. So I figured, why not do a podcast regarding, regarding the bar. Can I say that correctly? specifically bar topics. Anyhow, if you need to reach me regarding the podcast, you can reach me at podcast@studyforthebarinyourcar.com. And remember, I'm also a law clerk. I do legal work, but I work for attorneys. I don't work for pro se individuals. I work under the supervision of an attorney. So if you are an attorney and you need some work done, you need a motion, an appeal, something has come up, call on me. I'm a law clerk. You can reach me at hello@legalwriterandlawclerk.com. All right. So thank you so much. And the next podcast is going to be on performance breach and discharge. We'll see you soon. Bye.